Hello everyone. Now we are looking at one of the most powerful protections in the world of privacy, GDPR Article 22. The formal definition states that a data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. In simple terms, this is your right to a human handshake. It means that for the big stuff in life, like whether you get a mortgage or a job, you shouldn't be judged only by a computer. Stay with me here because this isn't just about avoiding a robot boss. It's about making sure that if a machine is going to change your life, a real human is responsible for that choice. You have probably seen this at the office, where people say, the system won't let me do that. Article 22 is the law that says sometimes a person must be allowed to step in. So now that we've mastered the basic idea that humans have a right to be in the loop, you might be wondering what solely actually means in a world where humans and computers work together every day. Well, that brings us right into our next step, which is the definition of solely automated. Now let's look at the word solely. The formal definition refers to processing that is carried out without any meaningful human intervention in the decision-making process. In simple terms, this is the rubber stamp trap. Let's break this down together. If a computer decides to reject a loan and a human just clicks confirm without actually looking at the file, the EU still considers that a solely automated decision. It's like a teacher who lets a machine grade your essay but never actually reads a word you wrote. To avoid Article 22, the human intervention has to be meaningful. The person must have the actual authority and competence to change the result if the computer got it wrong. So, now that we've mastered the fact that a fake human review doesn't count, you might be wondering exactly which decisions are big enough to trigger these rules. That brings us right into our next step, which is legal and similarly significant effects. Article 22 only kicks in for decisions that have legal or similarly significant effects. The formal definition refers to decisions that affect a person's legal status, legal rights, or their circumstances, behavior, or choices in a similarly significant way. In simple terms, this is the big deal threshold. If an AI recommends a movie you might like, that's not a big deal. No rights are lost if it suggests a bad comedy. But if an AI automatically rejects your application for a university or decides you aren't eligible for social security benefits, that's a very big deal. It changes your path in life. The law is there to protect you from being locked out of society by an algorithm without any way to argue your case. So, now that we have mastered the threshold of what counts as a significant decision, you might be wondering if there are ever times when an automated decision is allowed well. That brings us right into our next step, which is the three exceptions. There are three ways a company can legally use solely automated decisions, often called the derogations. The formal definition permits these decisions if they are A. necessary for a contract, B. authorized by law, or C. based on explicit consent. In simple terms, these are the golden tickets. Think about an online insurance quote. If you want an instant price, it's necessary for the contract to use a computer. Or, if you specifically check a box saying, I agree to let the AI decide, that's explicit consent. But remember, even with a golden ticket, the company can't just walk away. They still have to provide a safety net for the person being judged. So, now that we've mastered the three ways a company can get permission, you might be wondering what that safety net actually looks like for the person on the other side. Well, that brings us right into our next step, which is the right to contest and human intervention. Even if an exception applies, the law requires suitable safeguards. The formal definition at least includes the right to obtain human intervention on the part of the controller, to express his or her point of view, and to contest a decision. In simple terms, this is the right to argue. You've probably seen this at the office when a client is unhappy. They want to talk to a manager. Under the GDPR, if an AI rejects you, you have a legal right to say, I want a human to look at this, and here is why I think the computer is wrong. The company must have a process where a real person reviews your specific story and has the power to flip the switch. So, now that we've mastered the right of a person to demand a human review, you might be wondering how they can even start that argument if they don't know why the AI rejected them in the first place. Well, that brings us right into our final step, which is the right to an explanation. Finally, we have the concept of meaningful information. The formal definition from Articles 13 to 15 and Recital 71 requires the controller to provide meaningful information about the logic involved as well as the significance and the envisaged consequences of the processing. In simple terms, this is opening the black box. You can't just say the computer said no, you have to explain the why. If a credit card was denied, was it because of a late payment 5 years ago or a low income today? Providing this logic gives the person the ammo they need to exercise their right to contest. It turns a mystery into a conversation.